So tonight we are meeting to talk about the Utah Legislature, kind of some of the things about how it works and the lawmaking process. By way of background, my name is Austin Hepworth. I'm an attorney. I've been an attorney now for 13 years almost, and have done a fair amount in Utah with the legislature and bills and constitutional work. We currently have an organization called Believe that works with people who are proactive, trying to build things, do things, create things, whether it's a business, a nonprofit, legislative effort. And so we've worked with a fair number of people, including filed a brief at the Supreme Court a couple months ago in defense of religious liberty. And if so, we just have a lot of different activities across the board, but we like to work with people. We like to help empower people to be better advocates, to better understand the law, particularly because we feel the law is very connected to a lot of our life anymore. There's a lot of law and a lot of things taking place. So when we meet today, feel free to ask any questions that you have. Feel free to jump in. You can, there's not, I think that there might be a few more people join, but there's not a lot of people. We're not having hundreds of people talk over each other. And so you can chip in if you want, or you can use chat, whatever you prefer. I try and check the chats occasionally. When I'm presenting and it's on sharing a screen where you see my screen, I don't see the chat. And so I have to come back and check that occasionally. But if you have any questions off the bat, feel free to let us know. Otherwise, we'll jump into some of the things that we're going to be discussing. So I will get the screen shared here. Still learning the system. But hopefully you can see that. So again, we're here to talk about the Utah legislative process. Utah legislature meets starting on Tuesday next week, I think. And there's quite a few bills out already. There's a lot in the queue if you've been looking. So one of the things we believe strongly in our organization is that you are good. We focus on that a lot. There's a lot of good in people. And we try hard to work with people across the aisle. So Democrat, Republican, Libertarian, anything in between. We want to find the good and we want to build and create. We don't always believe that government's the best way to do that. But the government is necessary at times to do certain things. Law is necessary at times. And I think that there's an appropriate sphere of government and an appropriate sphere of private action. But we really encourage people to be more than just a good person, meaning don't sit there and not say something bad or not say something mean, but to actually become proactive and do something. And so we believe it's not enough just to be good. You must be good for something. You must contribute good to the world. The world must be a better place for your presence. And the good that is in you must be spread to others. The law process, the legislative process here in Utah gives you a chance to spread what you know is good. If you have something inside you that you know and feel, make something of it, do something with it, because these laws will impact Utah. They change things. Some of them are subtle changes that have pretty big impacts. We'll hopefully get time to look at one of those tonight that's proposed. But I believe strongly that you have the capacity to understand the law. The law, the entire legal system is complex. I don't think there's any person, even attorneys, that understand the whole thing. And we don't expect you to. But if there's something you're passionate about or feel strongly about, you can learn that. You can wrap your arms around it. You can get an understanding of it. And we want to help you with that for the things that you care about. And so one of the things we offer is, if you want, this presentation's in Microsoft Teams. It's an app that allows for collaboration, file sharing, chatting, different things. And we can invite you into the Believe Ventures system, I guess, in Teams. And we have a collaboration where you can talk about this legislative session. You can ask questions during the week. You can put things in, get some feedback. Because in these discussions, they're about an hour long, we won't have time to cover all the bills. There'll be probably over 800 by the time the legislature's done. Not all of them will need to be covered, but that gives you a chance. If you'd like to be part of that, you would email us and let us know you want that specific invite to be part of that chat. I know that some people asked from yesterday, and so we need to get back to you on that. We'll try and follow up by the end of this week on that. But by the time the legislative session starts, we hope to have that. We do ask in these that, or we do expect, I should say, that we have respect for each other, civility, no name calling, no bashing, but that you do share your beliefs and opinions. We want to understand why you believe what you believe, why you feel what you feel. And we ask that you listen to learn about the issues. Tonight, we won't go super heavy into the issues yet. And we'll talk about a few as examples of some of the things we learn. But we're going to focus on understanding how laws are interpreted. So we'll just kind of go through this fast, and then we'll pick a bill or two. And the bills we pick will be different from yesterday's discussion to go through and look at to understand some of these things. But here we have, when you interpret law, the fundamental rule in interpreting law is that all words matter. There's no words that don't have meaning. And so if you look at a bill and you say, oh, it doesn't make any sense, we'll just ignore it. That's not how law works. And the attorneys that draft the laws are trained to keep out words that aren't necessary. And so if it's there, it has meaning. It's doing something. The word shall is usually a mandatory term. It usually requires action. And so if it says the government shall regulate this, for example, then they have to. But the word may is permissive. It's discretionary. Gives the government the option to if they want to, but they're not required to. And so quite often I'll have people contact me saying, hey, I just read this. This is something the government says, the law says the government should do it. They're not. Can we do something about it? But it says may, and the government doesn't have to. Another operative term that's changes the meaning quite a bit is the word and or. And means two or more conditions have to be met in order for the law to be broken or satisfied, depending on the way it's written. Or means only one of multiple things must exist at the same time. And we'll see some examples of that in the laws we look at as well, where there's a list. Sometimes the law will make a list and say, if someone does A, B, or C, then they're guilty. In that situation, you don't have to do all three. You only have to do one of those. But if it says if someone does A, B, and C, then all three conditions have to be met. And again, those are terms that come up quite a bit in the law, these four words that are in almost every law in some way or another. There's no requirement, though, that law uses ordinary English or ordinary meaning even. You can read a term and think you know what it means because you use the term in your normal language, but the law may have a different term to it, may have a different meaning. So the law has a definition section where they actually define words and give them meaning. And the meaning put in the law is what prevails over normal English language. And so as you read the law, you'll get used to recognizing what's probably defined somewhere else and what's not. It kind of becomes habitual. But when you're learning it and trying to pick it up, you always just check the definition section for something that's defined. And I'll show you where that's in the law as well. But it's usually at the beginning of the chapter. They usually put definitions first, though they don't always. They sometimes put it elsewhere. Another thing is if two parts of the law might conflict. So sometimes language has multiple interpretations to it. If one interpretation would cause a conflict in the law, but one would harmonize the law and make it work together, judges will pick the ones that harmonize things. They presume that laws are written to work together, not against each other. But there are times where the conflicts are kind of irreconcilable. The drafting attorneys didn't catch that they should have changed something else. And so if there is conflicts that can't be reconciled through interpretation, the more recent additions to the law will carry more weight over older parts of the law. And then if the words are clear, the court will enforce it as written, with the exception of certain public policies that they won't violate, or constitutional provisions. But if the law is ambiguous and they can't figure out exactly what they mean, they may look to legislative intent to fill in holes. And that's where they go and try and get a grasp for what the legislature intended when they passed it. And they might look to committee hearings, they might look to drafts and revisions, they might look to what the speaker says about it, a number of those things. So are there any questions on any of that so far? I know it's quick, but we'll try and give some examples of those. Well, let me come back here. Just check. And then again, if you have questions, you can put those in the chat. But I will share my screen again here. This is the Utah legislative website. It's a very good website. Utah has done a great job in making the law fairly accessible in Utah, at least the code portion of it, written portion. The judge portion still is a little bit difficult, but that's just the nature of judicial decisions. But this is something to give Utah kudos for, is how hard they've worked on making this accessible, up to date, and good. Things generally get updated in pretty real time. So if you're on this website at le.utah.gov, you can contact all your legislators by going here. You can figure out, find by address. You can look at different things to see who's part of things, where they're at. You can look at committees and their assignments. Committees are an important part of the process, and a place where you have quite a bit of say and power to go up and talk about whether you like a bill or don't like a bill. And I'd encourage each of you to take some time to join a committee meeting. I don't know this year if they'll be broadcasting them. Last year they had in-person and video conferencing options. But there are a number of committee meetings where no one really shows up. And so if one person appears and talks about things, it can have a fair amount of influence. But to find the bills for the session, you go to bills and you go to 2023 bills and click on that. And then they have a list of bills here. HB means it's a House bill, originates in the House. SB means it's a Senate bill and originates in the Senate. In Utah, the main difference between the Senate and the House is that the Senate covers a bigger district than the House, so there's less senators. They represent more people. There's more House reps. And so the Senate generally has less bills. They have fewer bills that get put out because there's fewer representatives there. But generally, by the end of the session, the House is going to have put out over 500 bills, and the Senate probably 200 to 300 on average. So you can click on the plus for any of these to look at different bills. Utah has a requirement that each bill only have one subject to it. And so it's not like the federal legislation where you can have a lot of pork added to bills. Utah is going to stick to one subject, and they're going to require that that's disclosed, so people know what they're voting on. And I think that's a good thing, really helps. But you can go through and get an idea of what the bill is talking about, but they're not always exactly, sometimes the one subject thing gets fudged a little bit. And when you go through, you can look and see general subjects, if it's anything you're interested in or not. If you click on one, it takes you to this page that has a number of functions on it, where it shows you the sponsor of the bill, the person who requested it be drafted. Every bill has a sponsor, and then when it goes to the other chamber, whether that's the Senate or the House, there'll be a floor sponsor in that chamber that has to be here if the bill is going to be put forth in that chamber. So by the end, if a bill is moving through, It'll have two people. They give you the information here where it shows you last action, things that are happening. You can kind of follow that. You can actually choose to sign in and follow bills through the tracking page. So if there's a bill and you want a status or update every time something's changed on that bill, you can do that tracking and get notifications. And those notifications are pretty instant as soon as the status is updated. The status here shows you the last actions and the whole history of the bill when it was created. So it was numbered but not distributed yet. But then by the same day it was publicly distributed. It was sent to agencies, so on and so forth. Goes through that. If there's any hearings or debates scheduled, you'll see this more once the session is open. It will show it here so that you can see if anything's coming up and give you information on committees or where that will be taking place. When you're in this, Utah has highlighted provisions where they go through and give a general description, and then they give some highlights from it. And they try pretty hard, I think, to highlight things of substance that are happening in the bill. But again, it's not perfect. There are some things of substance sometimes that don't make it through into the highlighted portion. Now, the thing to understand about how a lot of representatives work, they're crazy busy. Legislative session is a very stressful time. A lot of people wanting to talk to them. And so if they're going to read a bill, they're going to check the highlighted provisions for the most part. And other than that, they're going to rely on input, where it's kind of a presumption that if there's something bad, someone's going to let them know about it. And that's where it falls on us, I think, as citizens, to pick the issues we care about and really work to say, we're going to let our government representatives know if there's something bad or something that we support, because they are relying on people in the process to notify them. Because again, they just don't have the time to read through 800 bills. Most of us that aren't even up there don't have that kind of time. And so we can all rely on each other to some extent, where we help each other and pick our topics that we care about, share about it, and then trust that others are picking their topics they care about and sharing about those too. So every session, there's some bills I've never seen that someone will bring to my attention, and I'll say, oh yeah, that's a concern. Let's move on that. But you can divide things up with friends if you want. You can just pick subjects. You can talk to other groups. But don't try and do it all, because you'll certainly burn yourself out trying to stay on top of everything. But this one is a Government Records Access Amendment, where we've had some issues come up, going back to the federal government level even, where government officials are using personal electronic devices for certain communications. And there's a question about, well, can we get access to those records? Because in Utah, you can make a government records request, a GRAMA request, they call it, and get information back. But if that information is on a personal device, it's been hit and miss on whether anything comes back or not, whether the government goes after that official to get it back or not. And it has not been consistent. And so people have concerns about government officials using personal devices and not being subject to public scrutiny. And so this bill is attempting to address some of those concerns. I'm not here saying whether it's the right or wrong way to go about it, but to me it was an interesting one to look at as we look at how the Utah Code works and how statutes are interpreted. So we have Utah gives you a list of everything that's being affected, existing code. So when it says amends, these are existing codes. Enacts means that we're putting in something new. And you can hyperlink to these. Utah, I've always loved in these bills, even in the proposed bills, they have links and you can see things. Sometimes it links you back to the bill if that section's being changed. And sometimes it links you to the actual law. But if you need to find the actual law, which is always a good thing to do, the way to understand Utah code is these three terms are a roadmap, pretty quick roadmap. And if you're on the Utah State Legislative website, you click on code, it takes you to this site, which is Utah code, and it listed by title. So if you're back looking at the bill and you have 20A, that number, that first number is the title number. And so we can go to 20A and realize, oh, there it is. We're in the election code. And then if you look back at the number and it's -11, then it's talking about chapter 11 right here, which is taking us to campaign and financial reporting requirements. And then if you look at this -1205, this section is divided into, this chapter, sorry, is divided into parts. 1205 you don't see, but 12, that 1205, part 12 means anything that starts with 12. So you click on that and then we get to section 1205. So this is what they're proposing to amend with their grammar records. So it's interesting, we're looking at grammar records, but now we're in campaign and financial reporting requirements. And you can see here, there's that 20A-11-1205 because we've made it in with that map pretty quickly. So that's how Utah code works. Those three things will take you down to a code provision. If it goes further, if you said parenthesis 1, then you'd be talking about just this one part here. Utah code is drafted nice in that it shows you, we have subpart 1 right here, for example, and then we have A, B, C. And we know that A, B, and C relate to what 1's talking about. 2 then talks about A and B. A also has 2 subparts in it. And so these subparts make up part of A. A and B generally go together under 2. They usually group things that go together this way. When you look at the bill, it's not broken up with the spacing over as well. So if you see the bill, you'll see there's 1, there's A, there's B, there's C, like there is there, but they're not all tabbed over. So it is a little bit harder to follow in the bills. But you can always look and say, okay, subpart 1, and then if you're not concerned with that, you can skip to subpart 2, subpart 3, knowing that those are independent parts doing different things. Here, if you get down, you have subpart 5, you have A, B, C, and then you have I through VI. These I through VI relate to subpart C. And you can see that here. If you're in 5, we have these. This is actually subpart D here in the existing law. And so that is interesting that those are slightly different. Oh no, sorry, it is D. I'm looking at it wrong. D's right there. So D has the I through VI, same as here. D with the I through VI. So sometimes looking at it this way helps you see and follow along for reading purposes a little bit better. But here, whenever a provision is changed, they have to put in the whole section and then show what's being changed. So right here, actually the only change that's happening, you can look it through, it's all normal text until you get to here. There's something crossed out and then there's something underlined. So this one section on financial reporting with campaigns reference this Government Records Access and Management Act. And that section, the numbers have been changed, so they had to change it here. Otherwise, the substance of that section is not changing. If we look at section 63G, which is now being changed, it's a definition section. So you see definitions right there. And this is something to understand when you're trying to interpret the law. If you're here at Utah Code, and you go down to 63G, General Government, each chapter will usually have definitions at the beginning of it. So we're in chapter 2, you can see, which is the Government Records Access and Management Act. Part 1 is almost always where definitions are. They usually put it at the start. They have title here, and then you see they have legislative intent. I'll show you legislative intent here, because what the legislature is recognizing is they said, you know what? Passing such a big law, when they did this, they said we might have missed something. There might be something we didn't think about. So they actually put their legislative intent in the law so that if a judge is trying to figure out an ambiguity, they can turn to this intent to say what the legislative intent is. So the legislature will do that sometimes. But definitions are right here, section 103. And these are the terms where you think you might understand what it means normally, but they actually have a specific definition of it here. Classification, computer program. So for example, computer program does not mean. So they're saying some pieces that computer program does not include. And contractor, the word contractor, the word controlled records, all of these things, even explosives, are defined in this law. Here, they define individual to mean a human being, which is different than a person, because a person can include a corporation, a partnership, a business. And so that's important to understand if you're reading the law. Sometimes we think person, oh, I know what a person is, but in the law, person usually includes a business. Individual doesn't, but that can be different law to law based on how they've defined things. So this is a pretty long definition section, but you have to be able to check these as you go through this law to see what things actually mean. And so you can see here, they put in the whole definition section that we were just looking at. And if we scroll down, we're going to eventually see what they're changing. And what they're changing here in the definition section is this underlined portion where they are adding in new language. They're going to define personal electronic device. And for their definition, we can see some of the ors and ands at work. So we have means a device that enables access to a computing service or other things. And then it doesn't say and or yet. So we have a little a with an I and a double I. And then we have a triple I. So this large A, B, and C are modifying just this double I. And so if we look for or and and in this list, we see an or right here, and we see an and as well. So what this is telling us is that to qualify as a personal electronic device, it has to satisfy subpart I. And then because of this or in the big A, B, and C, it has to satisfy one of the three things in subpart 2. So it's owned by an individual who is an officer or employee of a government entity, or is partly or wholly paid for by the individual, or uses a data plan that is partly or wholly paid for by the individual. So if one of those three conditions is met, then subpart 2 is met. And then the and at the end means subpart 1, 2, and 3 has to be met, and is used by the individual for government purposes or for the transaction of government business. So a personal electronic device is only defined to be that if I, double I, and triple I are met. Double I is met if one of the three things there are met because of the or and and. So that's just a quick way to look at that and see that. Ultimately, what this law does, or what it proposes, what this bill proposes, is that a government entity may, so we see the may at work, which means that the government entity doesn't have to do this. It gives the government authority to do this, but they don't have to. But if a government entity wants to, it can now conduct a search on a personal electronic device of an officer or employee of the government entity. And then it says if the officer or employee consents to the search, or, so here's the or they can do something else. They can request the officer or employee to conduct a search on their own device. So they can say, hey, if you let us, we'll get on your device and check it out. Or we can request that you do it yourself. So, hey, government official, you got to go do it yourself. Obviously, there's still a little bit of concern, I think, with government officials doing their own search. But But then it goes on to say that if they're requested under 1B, so if the government says go do it yourself, the officer or employee who conducts the search shall provide, so that's mandatory. So if the government entity says you have to go search your own device, then the officer or employee has to provide a sworn declaration certifying that they have conducted the search and that they provided everything responsive to the request. That sworn declaration is provided to the government entity. And so a governmental entity that requires and receives a sworn declaration under subsection 2, which is right here, then may rely on the sworn declaration. So they don't have to, but they can. And if the sworn declaration is later shown to be false, the government entity is not liable because it's false. So essentially they're saying, this is what we want to do. We want to make it so you can force someone to search their device. They have to provide the sworn statement. If the sworn statement's later shown to be false, government entity is not liable for that. But down here we add in the subsection 5 that says it's a Class B misdemeanor for them to provide a sworn declaration that is materially false. So curious if any of you have any thoughts on whether this is a good or a bad update to the government records request. To see if any of you have any opinions on government records. Have any of you ever filed a grammar request? Maybe not. Yeah, do any of you have thoughts? I know it goes back to Hillary Clinton days where she supposedly had emails that were on private, email communications and things. Do you think we should have access to be able to request records off of personal electronic devices of government officials?
Well, that's a good question, Austin, because if if it's government business, then I would say yes, but if it's personal business, I would say no.
Yeah, and so, but I think the question becomes, how do we tell?
Can't tell. Good question.
How do we tell? Why are they using their personal device for it? One person in chat said, yes, we should have access. And it is, again, it's we have personal emails, obviously, personal phones. I know that we've had Utah officials with this issue where they have Facebook pages and it's not always clear. Are they saying official policy or opinions from the body they represent? Are they not? But this was, again, it's an interesting step forward where they're saying the government can choose to, if they want, tell an employee or an officer that they need to search their phone. And if they're told they need to search their phone, they have to at least provide an affidavit, sworn declaration that says, yeah, I searched it. This is all the government stuff, or there was no government stuff. To me personally, I'd say it seems to strike a decent balance of not being too onerous on the government officials. It still gives them some privacy in their own thing, but it gives them some risk if, somehow someone could prove that they had something. And usually if you have a communication, there's always somebody else on the receiving end. So if you say there's nothing, the person that received it would at least know there's something. They may not want to disclose it either. And so, maybe it's not super enforceable. But to me, I would say I think this is a good step forward towards government accountability and transparency and a decent way to try and strike a balance at the moment.
And Austin, who counts as a government official? So, as an employee of the state, this is Rich, by the way, would I count as a government official?
being employed for the University of Utah Healthcare?
Oh, correct.
It's a good question. So we can look. So it talks about here an officer or employee. And we can see if they actually define officer or employee in here of the governmental entity. And they may not. They often go in alphabetical order. So officer doesn't appear to be in here. Let's see if they define employee or not. They don't define employee. They do define elected official. But presumably, if the healthcare system was considered to be part of the government and you were an employee of that, then you could be ordered to disclose things that are on your phone if that comes through a public records request. And so that
Okay.
extends to any employee of that government entity.
Yeah, interesting.
But it's a good question. And that is an interesting question. Should there be a level at which we're not interfering with employees' personal devices? As if you're the security guard or the janitor and you're just employed for a government entity or an agency, do you need to, go through that? But in the same vein, if you are an employee of the government and you get government funds, some would argue yes. But again, the government entity itself, it's a may term in there, so they don't have to request that you produce records if there's a government records request that comes in. Typically in government records requests, people are looking for higher level things than what lower level employees have said. But if someone filed a grammar request and asked for certain information, that could be something that they come to you and say, hey, you need to search your device. Let us know who you've emailed or talked to about this, and put that out there.
I should keep my text strings really clean.
Yep. Or only do work things on work devices.
Yeah, yeah.
Which is something that I think it's hard for everybody because we have work email on our phones and all kinds of things. But it is something that government entities have to decide to how they handle. Each one can have their own rules on it, whether or not you have it. I know that, the governments are moving to ban TikTok on government devices. And they can regulate a number of those things. But to me, I'm a fan generally of accountability with government, and transparency and the ability to get information. And I do know that we've had some issues and concerns where we have government officials that are circumventing some of these grammar request abilities because they just use personal devices. So to me, it seems like a decent bill, decent step forward where it's not too onerous. And if you don't use your personal device for government communications, then you are, you're not obligated to produce anything. You can just say, I don't have anything on it. As a solution there. But another one I want to talk about, just to give you an idea of little changes that can have some big effects and impacts. Share my screen again. This is one that is being proposed. It's called a joint resolution. And normally joint resolutions are where the House and the Senate agree on something. Those normally don't have the force of law because resolutions aren't signed by the governor. And so a lot of people don't pay attention to all the joint resolutions because a lot of times it's just fluffy stuff that's said. But this joint resolution amends the rules of civil procedure. And under the Utah Constitution, you can actually see it right here, that the legislature has the ability by a 2/3 vote to change rules of procedure that have been adopted by the Utah Supreme Court. So generally the Utah Supreme Court sets court rules, And but as a check and balance, the legislature by 2/3 vote can modify those. So if this resolution is to pass, it has to pass by 2/3 vote of both the House and Senate. And this is something that one of the people that have signed up for this asked about, brought my attention to. I hadn't seen it till I asked about it. And they were asking what it was doing. So if we go down, we're talking about injunctions in Utah. And injunctions are an order from a court to usually not do something. And so if you're trying to rule that a law is unconstitutional, you will move for an injunction, an order against the government saying you can't enforce this law anymore because it's unconstitutional. Or if someone's about to tear your house down and they don't have permission to do it, you would file an injunction with the court getting an order to say, don't touch that house. You can't take it down because you've got the wrong house or whatever. And that's really happened to people where their house gets torn down and the people at the wrong house. Shouldn't laugh at that, but it does happen. So Utah Supreme Court's had some rules that have been in place a very long time about how you get an injunction. And they have a rule specifically on what they call preliminary injunctions, which are injunctions that issue before a full trial has taken place. And preliminary injunctions and then temporary restraining orders are kind of at even higher level, where you just literally kind of run into court, say, hey, judge, this issue is so serious, you need to tell them to stop until we can have a trial on this matter. And to get one of these, there's a fairly high burden. And the court had rules about these restraining orders. So these temporary restraining orders are the preliminary injunction. So they're saying if you're not going to have a full trial, you're alleging that things have to take place before that. They said that they can only issue upon a showing by the applicant that, and then you can look at the old law. Here's the old one that started. It starts with 1, 2, 3, 4, and it's an and. So you had to show all 4 things to get one. If you look at what's changed here, they've taken E4. There's a substantial likelihood that the applicant will prevail on the merits of the underlying claim. And they've moved it up to E1, but they left off this portion of it. So what's really happening is they are getting rid of this language. They're changing the order, putting something from the 4th place to the first place. But that, in case precedent, it doesn't matter. The court doesn't care what order they come in. They have to, all 4 have to be there because there's an and involved. But they leave that part off. So the question is then, what is that? What are they taking out and why? When it says, or the case presents serious issues on the merits, which should be the subject of further litigation. Well, what happened in Utah in the last little bit, or across the nation, is we had, and this again, this is very long-standing law in Utah. This has been the case with injunctions for quite some time. And generally, a judge can say, ooh, I don't know who's going to win this one yet, but the issues are so serious that we're going to say, don't do anything yet until we resolve the issues. And so the Supreme Court gave people the ability to say, oh, this is such a serious issue that we need to check it out before, we don't know who will win, but we need to resolve it. And they're taking that portion out to say you have to be able to prove you have a substantial likelihood that you're going to win. So we have a pretty high burden to say right up front, you haven't seen all the facts yet, Judge. We haven't done discovery. We haven't gone through the whole process, but I've got such a compelling case. It's pretty clear I'm going to win. That's hard to win on with an injunction. And so generally judges will say, yeah, this case is serious enough that I'm just going to stop people from acting for a little bit and we're going to check it out. So I don't know if any of you know in the news, the big Utah news in the last few months, what case has been, or what issues have been enjoined by a court under this standard. But it followed in the wake of Roe v. Wade. When Roe v. Wade was overturned by the Supreme Court, Utah had a law that went into effect that banned abortions for the most part, if Roe v. Wade was overturned. And the ACLU, others challenged that law. They filed for an emergency injunction in court, and they said, hey, they said Utah has this new law coming into effect, and they asked Judge Stone and said, this is a serious enough issue that we don't think it's wise to throw, to ban abortion. And then if you're going to later rule that Utah Constitution grants a right to abortion, to then reinstate it. They're saying there's serious harm that comes to the moms. There's serious harms that come as a result of that. And so they're saying that we're not even going to tell you right now who's going to win or not, because we don't know. It's a brand new issue under Utah Constitution. They said, but the case is serious enough, the issues are serious enough, that you should put that Utah law on hold until we figure it out. Judge Stone agreed with them and said, yeah, the case is serious enough, the issues are serious enough that we're not going to act on this until we've had a chance for the full legal process to play out in the courts, full judicial process, to go through all the arguments on both sides, all the research, everything. So it's all in front of the judge. Look at all the history of Utah Constitution, et cetera, and then make a ruling so that people aren't thrown back and forth on where it's at, doctors, hospitals, all kinds of things. If this is changed, that's no longer a basis for an injunction. And the other thing that this puts in here, this new thing, which is fascinating, and which they know that there's a constitutional issue with, is they then say this change is retroactive. So that all restraining orders and temporary injunctions in place, or preliminary injunctions in place, currently, you have to go back and see if there's a substantial likelihood of success on the merits, or you have to drop the injunction. So what they're trying to do with this change to this law, this little change, is they're trying to force the courts to make an early ruling on the abortion decision before it's played out through the full judicial process. Now, obviously, people that are opposed to abortion might welcome something like that. People that are against abortion might be appalled at something like that. But we're playing this game with, over one issue, presumably. There may be others that I don't know about, but I think that the legislature has been a little upset at the courts for how long they're taking to rule on it, how much, kind of how circumspect they're being going through the issues, making sure they're doing what they feel is the right thing. And so this is kind of a slap back on that. And it's pretty rare. It's pretty rare for any change to be retroactive. And so they put in this thing about the severability clause, which says that the provisions of this rule are severable. And so they're saying that if a change we do is invalid, it doesn't kick out everything else we changed here. And I think what they're knowing might be kicked out as invalid is the Supreme Court might say, you can't make a retroactive rule like that. You can't affect injunctions already in place. And so they're saying if a court rules this portion unconstitutional, it's not going to change. The severability means that's not going to affect this portion, which takes away the case presents serious issues portion of it. So the only way to get an injunction in Utah moving forward would be, if this passes, would be to show that you're substantially likely to prevail. And so issues like the abortion ones or some of the serious societal issues that come out, other ones I think that may fall under that, besides just abortion, I think the courts enjoined Utah's transgender participation in sports law because of the substantial issues they say. And so on these societal issues, when the courts say, oh, these are some serious societal issues, let's take the full measure and not let these laws go into effect until we've had a chance to look at it all. The Utah legislature, at least, it's not the whole legislature yet. It's Brady Brammer so far, is proposing to get rid of that ability on serious societal issues for courts to say, let's take a moment and allow all parties to fully brief the issues. So a little curious, again, a little change, but one that's going to have a fairly wide impact on laws going into effect. More laws will go into effect on serious societal issues quickly. They could be overturned later, but then we kind of have that whiplash effect of if it goes into effect, it might get overturned later, it might not. But it's there for a time. So curious if any of you have thoughts on that, whether this is a good or a bad change to get rid of this last portion that allows them to issue an injunction if there's serious issues which should be considered.
I'm just guessing, but I think it's a bad idea.
Okay. Appreciate that. Anyone else have any opinions on that?
Well, I just wondered about in the case that you're talking about, the injunction against the abortion ban, when the Supreme Court has ruled that there's no constitutional right to an abortion, it's the Supreme Court for the state to come back and think they can do something in light of that, then it seems to me like there's not a lot of chance that that case is going to win, especially if it goes all the way to the Supreme Court, which means that it seems like it's just trying to throw just a little bit of time, just stumbling blocks in front of the ban just to buy a little more time to abort babies. So in that case, it seems to me like if that's all it is political more than anything else, then maybe something to limit the court systems from being used for political gains seems like a good thing to me.
Okay, and that's certainly appreciate that. A couple of pieces to know about what the U.S. Supreme Court actually said is the U.S. Supreme Court said in overturning Roe v. Wade, Roe v. Wade said the U.S. Constitution gave a right to an abortion. The Supreme Court said, actually, the U.S. Constitution doesn't talk about that. And it's not a right under the U.S. Constitution. They said, though, but it means it's a right that every state can regulate on their own. They said that the states have the power to regulate abortion, not the federal government. So when Roe v. Wade was overturned, it was taking the power to regulate abortion from the federal government to the states. If the states have power to regulate abortion, they can put in their constitution whether a child has a right to life and a fetus, or whether the mom has a right to an abortion, because the Supreme Court just said the states have that authority to regulate it. The ACLU in Utah has made the claim that the Utah Constitution, the state constitution, grants a right to an abortion, and that would be upheld by the U.S. Supreme Court. That decision under the state constitution will never touch the U.S. Supreme Court. Under this precedent anyways, because the U.S. Supreme Court said the states get to decide. So the Utah State Supreme Court will make the decision as to whether or not the Utah Constitution gives a right to an abortion or not. So in this situation, no one before has raised the argument in Utah about whether the Utah Constitution has that right or not, because it was found under the federal one at first. But now that the federal one's kicked out, these lawsuits have taken place in all the states that have an abortion ban that came into effect. And they're making the arguments under these state constitutions that they have a right to an abortion. So Judge Stone said, there is a chance that the Utah Supreme Court says there is a right to an abortion. So we should let this play out fully, so that we know essentially before we have that whiplash kind of thing in effect. And so it is, but I agree, if there's no chance of it winning in the end, it is a political thing. But I know that the legislature has been a little perturbed at the courts on some of these issues. And again, when we talk about societal issues, we talk about transgender participation in sports, we talk about abortion, a number of these things. I think all of us have opinions on them. But my personal thought is sometimes it's maybe good if we don't rush into laws. I don't mind if laws take a minute. to look at or to go through personally, because there is some value in that process. And I personally am very supportive of saying, if there's serious enough issues that we should look at, we should maybe say, don't do anything yet. And I do worry, if that's taken away, that there will be many rights that we have at some point that we're seeking redress for, in court. And if we can't prove immediately that we'll win, we may still win in the end. But if we don't have quite enough evidence at the start, we don't have a leg to stand on to get an injunction to start out. And there's a lot of things that can happen during that time. And I think we'll see these issues arise more and more in areas like elections. I know it's very difficult with election issues to get enough evidence up front. Usually you need, the course of a lawsuit to gather all the evidence. But sometimes there's some substantial issues. I think it can come up with gun rights. I think it can come up with free speech, freedom of religion type issues as well. Quite a number of areas that, again, we see a need, we see something going on, and then we say, oh, I've got to solve this problem. And so we jump into it. But this is one where I have some concern personally, because even on the abortion side, I personally don't support abortion in most situations. But I do think it's still wise for the court to take all arguments, fully consider it before it makes a decision. Because it is something that has large impact, in all the things going on. It's not easy to go through, but Melanie, what are your thoughts on that?
So I'm kind of torn. Oh, here, I'll turn my video on. I'm torn because I see the point that you're making as far as, let's have the time to be able to research the issues, especially with those hot issues like abortion and transgender sports. And, like you said, there's going to be gun laws and free speech and all the others. And at the same time, I don't want the legislature to be held hostage because, like you mentioned, the judicial system's taking too long. So how do we find a good balance between expediting the judicial system, but also having enough time to research these hot topic issues that are going to have impacts and repercussions down the road?
That's a great question. And I like that approach to say, yeah, I can see both sides. Is there a way to expedite the judicial process? And I'm very much involved in the judicial process quite often. It can absolutely be expedited. And I would think that the solution to this wouldn't be to take away the ability to put an injunction in place on these hot issues, but it would maybe be to say, instead of granting an injunction and then dragging it out 2, 3, 4 years in court, let's say that if you're going to grant it under this, should be the subject of further litigation, you need to resolve this within 6 months, for example. Courts can do that.
Mm-hmm.
And that is, I think, a very wise suggestion to make, to say, whoa, don't take away this right completely. Let's just put the burden on the court, if they're going to grant this, that they need to go through on these issues within 6 months or something, put some expedited things in place.
Who is it that does that? Like, that would say you have 6 months to be able to accomplish this? Go.
So
is that from the legislature?
The Supreme Court can say that, or the legislature can say that if they get the 2/3 vote.
Okay. So do you think that would be a better approach to this, as far as, if we're going to legislate something, let's give them a time frame where within it has to be accomplished, as opposed to saying the whiplash effect might come into play?
I say that the expedited process that you talked about is a very good solution to this concern.
So should we reach out to Representative Brammer and let him know our thoughts?
I would highly recommend it. Because this is one, again, where this one's going to have unintended consequences, where it's going to come back and bite people that care deeply about some topics.
Right. Well, and rather have the political system hold the courts hostage, or hold the legislature hostage with the judicial system. We can just get it going and just be done and have it be in law effectively, so that we don't have this hold up or the whiplash on either end.
Yeah,
Okay.
no, and that's, again, I think it's a great idea. Looks like someone else on here agrees with you that that's a good idea. So I love that. It's not, again, I hadn't thought of it yet. I just thought of, I don't love this approach. but I hadn't thought
Yeah.
through the solution yet. But that's a great solution. I feel. I'm interested to know if others have opinions on that or not.
Yeah, well, thank you for your explanation. That helps me quite a bit. I'll let everybody else chime in.
But yeah, if there are other people that want to jump in on that, you can. But thanks also for bringing that to my attention. Again, I looked at it just before this meeting. But these are things where we reach out, we propose solutions. It can go forward and have good effects. And sometimes if the sponsor disagrees with us and still wants to move forward, we can reach out to the other members and say, hey, just propose a substitute. And someone else can propose a substitute to say, hey, instead of taking it out completely, let's say that there's an expedited process for it. So, but we're at the end of our hour. So we are, again, you're welcome to stay on, ask questions if you want. But the recording will be available. We'll meet next Tuesday and Wednesday. Send me bills you're interested in or topics. We'll try and look at some of those. But we will just start going through the bills, talking about them, seeing if we can come up with good solutions to the issues and concerns. So I appreciate you attending and look forward to working with you all more.
Thank you so much, Austin. Appreciate your help and look forward to next week.
Sounds good. Thanks.